Wasik.
Good afternoon. May it please the court. My name is Michael Wasik. I represent David Abercrombie, who is the appellant in this matter. He is the defendant below in the foreclosure action brought by Wells Fargo. He is the fee simple homestead owner of the property, a named defendant, and it's our position, Your Honors, that Mr. Abercrombie had the right to defend this foreclosure litigation. He had the right to discovery in that foreclosure litigation, and he had the right to see the evidence presented at trial before the day of trial when it was presented against him. If you agree with any of those issues, Your Honors, then we submit that the proper remedy is to reverse and remand for further proceedings. Now, Your Honor, as to the right to defend, it is the bank's position all along that Mr. Abercrombie doesn't have the right to challenge the bank's action, doesn't have the right to challenge the prima facie case of the bank as they presented it, on the theory that he lacked privity and on the theory that he was barred by the consent judgment stipulation between the previous owners of the property and the bank. And we believe that both of those are factually false and legally unsound. As to the privity argument, Your Honor, their theory, Mr. Abercrombie purchased the property in fee simple from Lori and Dale Coates. And the intention of Mr. Abercrombie, as revealed in the trial transcript, is that he was going to take over the mortgage payments, and he intended to try and negotiate a better deal for himself, but it was his intent to take over the mortgage payments right away and go ahead and
without obtaining any sort of agreement to assign from the bank.
That's correct, Your Honor. That's correct. But
I'm confused. Was this house owned by a husband and wife before, or just one person, or what?
Lori and Dale Coates were husband and wife. They sold it to the Abercrombies, and
so
it's actually David Abercrombie.
One couple buying from another couple.
I think the deed is actually in David Abercrombie's name only, but yes.
Is it a quitclaim or a fee simple?
Warranty deed, Your Honor. I believe the record shows it's a warranty deed.
Okay.
So the issue here, Your Honor, is that Mr. Abercrombie bought the property in fee simple, moved into it. It was his homestead property at the time the foreclosure was filed. He was named as a defendant. He sought to defend. Initially, he represented himself pro se. Eventually, he did retain counsel. I was trial counsel for that litigation. The privity argument, Your Honor, is that, and this came up first during the discovery phase. When we sought discovery, I actually had filed a motion to compel after the bank responded to document requests with a single objection saying, David Abercrombie is not in privity. He doesn't have the right to obtain any of these documents. And the issue with that is that they were contending that David Abercrombie wasn't on the mortgage. Well, interestingly enough, neither is the plaintiff, neither is Wells Fargo in this case. They are the successor to the original lender, just like Mr. Abercrombie is the successor to the original mortgagor.
But Mr. Abercrombie never became a successor in the sense that he would be liable on the note and the like, right? He has no potential exposure on the mortgage other than to lose the house. To lose
his homestead, yes. That's the limit of his exposure.
But
however, he did
sued in the litigation.
He is named as a defendant by the bank.
The bank seek a protective order from your discovery, or they just object to it and you weren't able to, and you failed on your motion to compel?
They responded with a single objection as to lack of privity. We moved to compel before the magistrate. The magistrate ruled that because he had no privity, he wasn't entitled to a single sheet of paper.
Is somewhere in the rules of discovery and the rules of civil procedure that says you have to be in privity to get discovery?
There's no rule that I'm aware of, Your Honor. And in fact,
it has more to do with whether you're a party, doesn't it?
I agree with that entirely. In fact, I argued that in our brief, and I think the rules expressly say any party has the right to discover from any other party documents that are discoverable that may be relevant.
Otherwise, assert that they had a right to be protected from discovery. They just said he had no right to the discovery.
They did not. That's correct. They did not file a protective order. Okay. They didn't file. They didn't serve any other objection, if my memory serves correctly. So they just said no discovery at all. The magistrate upheld that. We objected to that. Took our exceptions to the circuit court. The circuit court upheld it. We actually tried a second time prior to trial, and that was the same result. It was the magistrate denied our protective order, and the circuit court did not choose to disturb that ruling. So again, the issue here was that if they're going to present documents against Mr. Abercrombie at trial, which they did, and many of which we had never seen before. We had seen the note and the mortgage and there may have been a couple other documents that were in the file already, but other than that, they refused to disclose a single sheet of paper that they were going to use at trial against Mr. Abercrombie to take his home from him. And when they did that, clearly if they're going to present it at trial, that's because it's relevant at trial, assuming it is, it's discoverable under the rules. So we were entitled to that discovery. We were denied it not once but twice, both of which are upheld by the circuit court upholding the magistrate's ruling.
So you got no discovery at all?
That's correct. That's correct.
No discovery of payments on the note, for example, and that kind of thing? That's
correct. There was an affidavit in support of the summary judgment, and there was some information submitted in support of the consent judgment with the Coateses, but there was that was different from what was introduced at trial.
This was stuff that was filed, not obtained in discovery.
Correct. And that actually belies the bank's claim made at trial that information was confidential, because they presented it already in the court file.
Were you permitted to, or was there any effort to take depositions in this case?
I don't believe we did take a deposition. I think after the ruling, it was very clear to us.
Request for production, lost on that, and then didn't seek anything more on it.
Well, we tried the request for production more than once, but yeah, I think we were focusing on the documents.
Okay.
Because in cases like this, documents really are where these cases turn. And so we were seeking, and had we gotten the documents, we might have taken depositions on those based on, especially if they had disclosed to us what they eventually produced at trial. For example, the AS-400 document, that was the only sheet of paper that showed that there was any possession of the loan at inception, which is something in this, this district is recognized as a legal requirement in a foreclosure case. Because again, that was something that they didn't even bring to trial with them. They had a recess to go print it out so they could present it. So we were as surprised, they were as surprised as we were that they were going to present that, apparently. Besides the right to discovery, the bank relied on this privity theory and this, I haven't addressed the stipulation. Let me address that briefly. Mr. and Mrs. Coates were also named as defendants. They consented to judgment, and the record will show that they had moved out of the property because Abercrombie had moved in, and they were given a deficiency waiver. So they were completely absolved of any responsibility by the stipulation. And throughout the trial and throughout the brief that the bank has submitted in this case, Your Honors, the bank is arguing that that stipulation prohibits Abercrombie from raising defenses, that the Coates were the only ones who could defend on issues of standing, on issues of performance of the contract, and so on and so forth. And it's clear from the case law, Your Honor, that the VMD case is one of the ones I cited at trial and also rely on in the brief, that even a junior lien holder, a material man, has a right to raise defenses like unclean hands and things like that. And so it's our position that someone who's a fee simple homestead owner, and not just a fee simple owner, but the homestead owner, constitutionally protected, has a superior right, or at least no lesser right, than a junior lien holder to raise defenses in the foreclosure action, whether at discovery or at trial. And in this case, both based on the privity argument and based on the stipulation argument, the trial court refused to let us cross-examine, and I was trial counsel, it shows in the transcript, refused to let us cross-examine on issues of whether the condition precedent on the default letter was met, and also refused to let us cross-examine on the issue of whether standing and inception had been proven, because the issue there was whether the allonges were dated or ever even attached. And those are all clear from the questions that were asked, the objections that were raised, and the trial court's final ruling on that.
Well, if you weren't a party to the note on and separating aside sort of are they in default and what the damages money, if the parties themselves don't raise a paragraph 22 defense, for example, it's a little unclear to me why a materialman or some other person in the lawsuit would have standing to raise those kinds of issues.
Well, the Rashid case and the David versus Sun Federal case, both of which I cite in my brief, do state that an owner who takes subject to the mortgage can raise defenses under the mortgage.
Well, yeah, you take subject to it.
And let me.
He didn't assume.
Right.
He didn't assume it, but he did take subject to. And let me explain why that's important.
Out of curiosity, is you're taking the property itself a default on the note and mortgage?
It could be at the option of the bank, but they never declared that, and they certainly didn't sue Mr. Abercrombie based on that. The only default they declared in this case was the non-payment, which he did. His testimony shows he attempted to cure. The issue of the mortgage. I think the difference between the assumption and the subject to is important here, in that it's an inversion of the way the rights work in this case. David Abercrombie is the fee simple homestead owner of this property. His rights are near absolute, except to the extent that the mortgage grants the bank's rights. So the analysis is not what are Abercrombie's rights. The analysis should be, what right does the bank have? Because if the mortgage doesn't apply to Abercrombie, then this case is over.
Is your theory that anybody that's in that house has the right to contest the mortgage foreclosure?
Well, tenants,
even a tenant?
Tenants in possession do have rights to defend because it's their possessory rights of interest.
They can challenge the validity of the mortgage?
No, they can't challenge the validity of the mortgage. No one in this case is challenging the validity of the mortgage. What we are disputing is whether or not the mortgage was performed per the agreement, because the mortgage defines the high watermark of the bank's rights to take the property. The bank has no rights to take the property unless it goes through the mortgage, and if some of those rights are conditional.
The warranty deed permitted him to assume the mortgage, did it not?
That was the intent of the parties, correct. And Mr. Abercrombie testified that he attempted to contact the bank to get that done, and they would not respond to him.
It's undisputed. He never followed through because he wanted a better interest rate. So in order for him to have the rights under that mortgage, he was required to perfect the assumption. And he doesn't deny he didn't do that.
I don't agree with that, Your Honor, and this is why. As the fee simple owner of the homestead, his rights are only impeded to the extent that the bank had a mortgage there. And if the bank's rights are conditional, as they are under the mortgage.
But his rights, were they not also conditional? Conditioned upon his assuming the mortgage.
That's his right in the property. He's a fee simple homestead owner. That's not conditioned at all.
Owner here, I guess what's confusing is we've got I'll call the prior owners, who are still 100% liable on the note and bound by the mortgage. And if they want to consent to judgment so that they don't have a deficiency judgment, and you didn't do anything about that in the purchase to your client, why don't they have the right to do this? Why do you, taking subsequent, have the right to keep them from protecting themselves under the note and mortgage?
We're not seeking to prevent them from protecting themselves.
I think your answer is that certainly, to the extent that the bank is attempting to enforce the mortgage against your client, you have the right to defend it.
That's absolutely correct. And in addition, Your Honor,
but the bank can't take the property and sell it. So they can't. So the initial people can't actually ever do anything because the bank can't take the property and sell it if you're continuing to fight about it.
The Coateses, their liability was as to the note only. They consented to judgment. A consent judgment was entered against them in 2010. They were done.
Their liability, but they had the right to the house as collateral at all times.
They ceded their right to the house when they sold it to Abercrombie. They gave him a warranty deed.
They have the Coates have no interest in the house.
They have no possessory interest in the house, no ownership interest, no nothing.
You don't care one way or the other.
Exactly.
It's your client's interest in the house that you're trying to protect.
That's exactly correct.
They have the right to have the house used as collateral on that note because of the mortgage. They were never taken off the mortgage. They didn't lose that right.
That's correct. That's the bank's right, though, not the Coates' right.
Right.
And so, to the extent
Abercrombie, to their benefit in a situation like this.
To some extent, because if the only way their liability would come up would be under a deficiency judgment, unless the bank filed a separate suit under the note, and the bank did not do that. They proceeded under the foreclosure. They were seeking to liquidate the property, and they let the Coates off the hook entirely. I mean,
have the Coates sued your client?
There was litigation between the parties. That's reflected in the trial transcript. But that was resolved, as I understand it, certainly well before we went to trial, and I think before the foreclosure was even filed.
You're about to your 15 minutes here, so.
Then I'd like to reserve the balance of my time, Your Honor. Thank you very much.
Okay.
Good afternoon, Your Honors. My name is Adam Schwartz. I'm with the Ackerman firm out of West Palm Beach office. I'm pleasure to be in front of you here today. I think that...
Tell me your name again.
Adam Schwartz.
Adam Schwartz.
Yes, yes, Your Honor. After reviewing the briefs and the record and appeal in this case, which I received a few weeks ago to take this oral argument, there's two things that I think that this appeal is about. The scope of defenses that are available to a defendant or the appellant, and if there was any error, whether it was harmless error or not. The Florida Supreme Court has established that there are limitations on the defenses that are available to a defendant like the appellant. They can't attack the validity of the note and mortgage. They're not entitled to contractual conditions precedent because they never assumed the mortgage. And so, in this case, you have the judge applying those limitations on defenses in certain circumstances, and then you have the judge allowing due process. The judge actually allowed cross-examination, notwithstanding the representations otherwise. If you look at the record, the transcript, page 73 through 77, on the most important document that's before the court, which is the AS-400, is the note tracking document that showed plaintiff's possession of the note. And at the time the complaint was filed, that was competent substantial evidence, and it was properly admitted to the court. The court didn't abuse its discretion in admitting that.
Go back to the discovery. Is it true they were not allowed to obtain discovery on payments, for example?
I believe that there was an objection raised that prevented them from having copies of the payment history. I think that those were also in the record, perhaps attached to a motion for summary judgment, so I don't know that there was error there sufficient to warrant reversal. In any event, I haven't heard, and I haven't read anywhere in the record or any of the briefs, specific prejudice if that was an error. You know, I take a lot of...
You know, that's kind of difficult to show where you haven't been given documents that you have requested. It's difficult for you to show prejudice because you don't know whether those documents exist.
Sure, and there's a mechanism for that to be brought before the court, and there could have been a proffer, but there was no proffer as to that issue.
Are they going to proffer if they haven't seen the documents?
Well, they saw them at the time of trial, and there was argument.
Well, they saw what the bank sought to introduce at the time of trial. They didn't see necessarily everything that was on their request to produce, did they? No, but there were only certain things that they brought up in their appeal as what they were seeking for. So I don't know that the entire scope of the request for produce. Well, now you're sitting here arguing that it was harmless error to deny them discovery, and I'm saying, well, because and that they didn't proffer, and well, how are they going to proffer if they don't know that they haven't seen the documents?
Well, they were provided some documents of discovery. I don't know that they were provided the payment history itself. I think that there was a discussion that it was in the court record because it was attached to a motion for summary judgment supported by an affidavit in support of that motion. But at the same time, and I've taken a lot of these trials, and for better or worse, documents don't come up until a few days or the day of trial. And I've always taken the position that if there's specific prejudice that's identified, then that's a bigger issue and we can have that analysis. But more times than not, there's no specific prejudice that's identified. What would he have said? That these was not the payment history? I don't think that there's any dispute that there was a non-payment default in this case.
Yeah, but you're limiting yourself to whether there's prejudice from the facts that they didn't see the bank's documents until the trial. And the question is, didn't they have a right to do broader discovery beyond what the bank intended to introduce?
Perhaps, but...
I don't think it's perhaps. I think under the rules of civil procedure, a party has a right to do discovery, and it doesn't have to be relevant evidence. It has to be calculated to lead to relevant.
Right, as framed by the pleadings.
No, it's framed by the pleadings.
Right, and in this case, they didn't have an affirmative defense that denied plaintiff's possession of the note and mortgage at the time the complaint was filed as an ultimate fact.
But if they want to keep their house, they're going to have to pay this judgment, right?
They would have to redeem.
And to redeem it, they have to know what the bottom line on that judgment's going to be.
And that information was provided to them. The time of redemption is before sale. They didn't offer any counter evidence to suggest any different calculation figures, and they were provided that opportunity at trial. So, going back to...
Are their redemption rights any greater than the court's redemption rights?
No, they were not. The most important document, I think, is the document that shows plaintiff's possession at the note at the time the complaint was filed. That's Exhibit 2 to the trial transcript. And there was voir dire that was allowed for the foundation of the admission of that business record. There was also cross-examination that was allowed as to that business record. So I disagree that due process was deprived from Mr. Abercrombie. If you look at the transcript, pages 73 through 77, he was allowed to voir dire as to the sufficiency, and he was allowed to cross-examine. As a matter of fact, the plaintiff's counsel objected and said this is going beyond the scope of voir dire. He's asking questions as to the credibility of this document. That objection was sustained, and the questions were allowed to continue. There's another section in the transcript where Mr. Waslick, appellant's counsel at the trial, sought to ask additional questions on what maybe we would consider more formal cross-examination, and those objections were sustained, but there was no proffer made as to what those additional questions would be, so the court can't consider that at this point, but there's a tell, right? There's a tell. He puts it in his appellant brief that what he would have asked, or he would have attacked the validity of the allonge, but that the Florida Supreme Court has said that you can't attack the validity of the note and mortgage. The copy of the note that's attached to the complaint shows the allonge affixed to it with the special endorsement to the plaintiff. So we know that that allonge was there, affixed to the back of the note, specially endorsed to the plaintiff at the time the complaint was filed. And Exhibit 2 of the trial transcript establishes that plaintiff had possession of that specially endorsed note at the time the complaint was filed, and that's competent substantial evidence. He was allowed to cross-examine on it. He was allowed to voir dire on it. So due process was provided.
There's a,
Yes, Your Honor.
I'm not sure that it's an argument direct to this appeal, but there's references to the fact that Mrs. Abercrombie is not a part of this lawsuit. Is that going to gum this up anyway?
I don't believe so, and this is, and maybe that'll be something for separate litigation at some point. But nowhere in the complaint, or the affirmative, the answer, or the unauthorized amended answer, does he allege anything about his homesteaded rights in the property, and the court specifically declined to adjudicate that issue at trial. So I know that there's a lot of argument that he's being...
You don't know whether this is a deed by husband and wife by the entireties and the property's homestead?
I don't think that that's been adjudicated. I don't think it's properly before the court. It wasn't raised in any of their defenses or their answer.
Okay.
They claim it in their brief. They claimed it at the trial testimony, but there was no motion to conform the pleadings to the evidence, and the court declined not to adjudicate his homesteaded rights in the property. The trial court did not abuse its discretion in admitting the exhibits. The witness presented by the plaintiff bank was a qualified witness, generally familiar with the policies for the creation of the business records for which he testified to, and they're from her company. Same company. It's not a successor service or business record case. Those business records met the hearsay exception, and they were properly admitted. And those business records established plaintiff possessed the note, endorsed to it at the time the complaint was filed. There's no contrary evidence to plaintiff standing in this case, and there's no defense that the plaintiff lacked possession of the note at the time the complaint was filed. And there's the original answer and affirmative defenses that were filed pro se. There's a one-line sentence, plaintiff doesn't have standing. I didn't see an order granting leave to amend the affirmative defenses, but there is an amended answer and affirmative defenses. Those have a lot of ultimate facts in them, several paragraphs on standing. None of them identify plaintiff's lack of possession of the note at the time the complaint was filed. Perhaps that issue is waived.
Before you sit down, and I failed to ask Mr. Waslick about this, but he has a motion for attorney's fees, and what's your position on his motion?
Well, he would be if he was a prevailing party, perhaps under the contract. No, he's not in contractual privity. I'm sorry, there's no prevailing party attorney's fees to him at all. I'm not aware of a 57105 motion, which would be a separate procedure, but because of the lack of contractual privity, he wouldn't be entitled to attorney's fees and costs. I don't think we would be entitled to them against him either.
You don't have a motion, so you won't get them one way or the other.
Maybe that's why you didn't.
Perhaps. There's several other points we could go over. I mean, I don't want to belabor the points. The brief, I think, speaks for itself, but the magistrate's report and recommendation was not an evidentiary hearing, so the magistrate rules as to evidentiary hearings are not applicable. The case was at issue. We have actually the pro se answer. There was never leave to amend to assert these other answers. So there was a motion to strike these affirmative defenses that was pending, I guess, at the morning of trial. That was denied, so there was no prejudice. There's case law that says that the at issue 1.440 can not going to require a reversal if there's no prejudice. The motion was denied, so he had all those amended affirmative defenses, or we can say the case was at issue because he was never granted leave to amend, so the original affirmative defenses to which there was no amended motion to strike the affirmative defenses are his affirmative defenses. Either way, the case was properly tried, and there's no prejudice to the appellant on that issue. I think the record before the court shows that the judgment should be affirmed because due process was afforded where it was necessary, and to the extent there was any error, which I don't believe there was, that error was harmless. There's no specific prejudice anywhere in the record identified as to any of the issues that he's complaining about for the discovery or any of the other issues. Even if there was an adjudication as to homestead, which there's not, the homesteaded rights are subordinate to mortgages. That's one of the known exceptions to homestead, and so that's really, I think, a red herring issue for this court. Respectfully, I ask that the court affirm the judgment. Thank you.
Okay, thank you. Mr. Waslick? Mr. Waslick, what I have in front of me just shows that you filed the motion. I'm not even sure what the grounds for the motion for fees are. So.
For the attorney's fees?
Yeah.
Yeah, I understand that, Your Honor, and giving some consideration to Mr. Schwartz's response.
If it's under the contract, you probably have a problem.
Yeah, I agree with that, Your Honor. I agree with that. So clearly that I think answers that question. As to, do you have any other questions before I launch into some responses?
It's undisputed from your client's testimony the one payment that he attempted to make was returned, and he doesn't contend that he made any other payments, right?
Well, actually, in fact, it was not returned to him. It was actually sent to the Coates.
Right.
So he never even got it back, but it was rejected. It was rejected. So any further payments would have been futile.
No further payments were made, and no further actual payments or in-kind payments that would have reduced this mortgage were made. So his basis for attacking the judgment amount would be through the Coates.
His basis for attacking the judgment amount, Your Honor, would be that it's the prima facie case of the bank to prove the amount due and owing, and that affects his right of redemption.
That the Coates have already consented to.
That's correct, but the Coates' stipulation is not binding on Abercrombie. That's something that the bank beats like a drum in their brief, and the case law is very clear that Abercrombie cannot be bound by someone else's settlement agreement. That is something that they rely on, and it's completely untenable based on the case law. The VMD case in particular is one of those where it was a foreclosure case. Junior lien holder, two junior lien holders, in fact, were basically the initial borrower consented to judgment, and the two junior lien holders said, well, wait a minute, we have a right to defend here. And the trial court denied them that right to defend, entered judgment. And that was reversed. That was the Fourth Circuit, Fourth DCA rather, case that we cite in our brief. So that stipulation doesn't bar Abercrombie from challenging the factual or legal grounds of the bank to go forward and take the home that he owned. Again, the bank's rights are limited to the mortgage, and if their rights are conditional, then he has a right to challenge whether those conditions have been met. Now, Mr. Schwartz identified a couple things I want to address very briefly, if I may. First of all, he indicated there's no counter evidence that was offered. And as Judge Northcutt suggested, we don't know what counter evidence could have been offered had discovery been responded to. And that's a critical issue here, is that banks' records are always internally consistent. And in fact, in our brief, we go through how some of the records that we did ultimately get on the day of trial showed that the calculations weren't consistent. And the default letter versus the pay history that was proffered, that was actually introduced rather, that those calculations were not necessarily consistent. Had we had the full records available to us, we might have been able to uncover the source of that discrepancy, but we didn't get it. We didn't get it. So we don't know what the records would have shown. We can't have made that proffer. As to the issue of the allonge, Mr. Schwartz suggested we were contesting the validity of the loan, the mortgage. I forget the exact word he used, but he used the word validity. I want to underscore once again, we're not contesting the validity of the fact that a lien exists, and Mr. Abercrombie testified that his intention was to honor that lien. The problem is that when this bank came to trial against this defendant, they had an obligation to prove that they are the ones who actually held the lien, and the allonge and the date of possession, date of endorsement, standing in inception, however frustrating it may be for this court to do, it's acknowledged again and again that that is part of the plaintiff's case. When standing is denied, again, it's one of the elements of the recitations in their complaint, and it's denied in the answer. When that's denied, that's a fact that they have to prove. And that's something that we are attempting to challenge, not as to the validity that a loan existed, not the validity that a mortgage existed, but as to whether or not these folks had the right to file this lawsuit against these defendants at the time they filed. And that's something that this court again and again has found is binding.
You need to wrap it
So
up.
I think that's it.
Okay.
Thank you very much.
Thank you. That concludes our docket, and court's adjourned.
Well done.
I had to find a theme through there that was not consistent with the briefs.
It's hard to argue somebody else's writing.
I didn't really like
Open brief. I know Nancy. I'll have it to law school.
Let's be together. Yeah.